Good morning. The Judiciary Committee will come to order, and without objection, the Chair is authorized to declare a recess of the committee at any time. Pursuant to notice, I now call up H.R. 5063 for purposes of markup and move that the committee report the bill favorably to the House. The clerk will report the bill.
H.R. 5063, to limit donations made pursuant to settlement agreements to which the United States is a party and for other purposes.
Without objection, the bill is considered as read and open for amendment at any point, and I'll begin by recognizing myself for an opening statement. 18 months ago, this committee commenced a pattern or practice investigation into the Justice Department's mortgage lending settlements. We found that the Department of Justice is systematically subverting Congress's spending power by requiring settling parties to donate money to activist groups. In just the last 2 years, the Department of Justice has directed nearly $1 billion to third parties entirely outside of Congress's spending and oversight authority. Of that, over $500 million has already been dispersed or is committed to being dispersed. In some cases, these mandatory donation provisions reinstate funding Congress specifically cut. The spending power is Congress's most effective tool in reining in the executive branch. This is true no matter which party is in the White House. A Democrat-led Congress passed the Cooper Church Amendment to end the Vietnam War. More recently, bipartisan funding restrictions blocked lavish salary and conference spending by federal agencies and grantees. This policy control is lost if the executive gains authority over spending. Serious people on both sides of the aisle understand this. A former Deputy Assistant Attorney General for the Office of Legal Counsel in the Clinton administration warned in 2009 that the Department of Justice has the ability to use settlements to circumvent the appropriations authority of Congress. In 2008, a top Republican DOJ official restricted mandatory donation provisions because, quote, they can create actual or perceived conflicts of interest and or other ethical issues, end quote. Any objections to this bill would be unfounded. Whether the beneficiaries of these donations are worthy entities is entirely beside the point. The Constitution grants Congress the power to decide how money is spent, not the Department of Justice. This is not some esoteric point. It goes to the heart of the separation of powers theory and Congress's ability to rein in the executive in practice. Nor does the bill restrict prosecutorial discretion. That discretion pertains to the decision to prosecute. Setting penalties and remedial policy is the proper purview of Congress. Opponents' central concern is that there may be cases of generalized harm to communities that cannot be addressed by restitution. But this misses the fundamental point. The Department of Justice has authority to obtain redress for victims. Federal law defines victims to be those directly and proximately harmed by a defendant's acts. Once those victims have been compensated, deciding what to do with additional funds extracted from defendants becomes a policy question properly decided by elected representatives in Congress, not agency bureaucrats or prosecutors. It is not that Department of Justice officials are necessarily funding bad projects. It is that, outside of compensating actual victims, it is not their decision to make. Rather than suspend the practice of mandatory donations in response to these concerns, the Department of Justice has doubled down. Just last month, a major DOJ bank settlement required $240 million in financing and or donations toward affordable housing. It is time for Congress to end this abuse. The Stop Settlement Slush Funds Act of 2016 bars mandatory donation terms in DOJ settlements. It is a bipartisan bill. It makes clear that payments to provide restitution for actual harm directly caused are permitted. It explicitly references the environmental context where the injury to the environment may be diffuse and there may be no identifiable victims. The bill deals with this by explicitly permitting payments to remediate environmental damage. If direct remediation of the harm is impossible or impractical, the violator is not let off the hook. The full penalty is paid, but into the Treasury. This bill addresses an institutional issue. That is one reason similar language passed the House last year by voice vote. I thank all of the bill's co-sponsors and I urge its passage. And it's now my pleasure to recognize the ranking member of the committee, the gentleman from Michigan, Mr. Conyers, for his opening statement.
Thank you, Chairman Goodlatte. Members of the Judiciary Committee, the Stop Settlement Slush Funds Act would prohibit the enforcement or negotiation of any settlement agreement requiring donations to remediate harms that are not directly and proximately caused by a party's unlawful conduct. The proponents of the bill claim that the Justice Department and civil enforcement agencies use such settlements agreements to unlawfully augment their own budgets as an end run around the congressional appropriation process. So here's why I am not in support of the bill. To begin with, these types of settlement agreements have been successfully used to remedy various harms caused by reckless corporate actors. For example, they've been utilized to facilitate an effective response to the predatory and fraudulent mortgage lending activities that nearly caused our economic collapse nationally. Settlement agreements with two of these culpable financial institutions, Bank of America and Citigroup, required a donation of less than 1% of the overall settlement amount to help affected consumers. I cannot agree with the claim that Justice Department has used these settlement agreements as a vehicle for funding activist groups. Notwithstanding the production of hundreds of pages of documents by the Justice Department, along with hundreds of pages of documents produced by private parties, we have not seen any evidence that the government included unlawful or politically motivated terms in its settlement agreements with Bank of America or Citigroup. It's also been asserted that the Justice Department and other agencies have augmented their appropriations through these settlement agreements. But existing law already prevents agencies from augmenting their own funds through civil enforcement. The law's already there. And these laws require that donations and settlement agreements have a clear nexus to the prosecutorial objectives of the enforcement agency. And both the Government Accountability Office and the Congressional Research Service conclude that settlement agreements providing for secondary remediation do not violate Congress's constitutional power of the purse. And finally, I'm also concerned that H.R. 5063 would have harmful consequences on the remediation of systemic harms in civil enforcement actions. Settlement agreements allow parties to resolve their civil liability by voluntarily remediating the harms caused by unlawful conduct. For some unlawful conduct, such as discrimination based on race or religion, secondary remediation of harms may be the only remedy available for systemic violations of the law. These lawsuits typically affect the interests of individuals who are not themselves parties to an action. Secondary remediation in these cases serves as an important tool to protect victims of discrimination through voluntary compliance and training programs. And so, my friends, this is why, given these concerns presented in the bill, I am accordingly forced to oppose H.R. 5063 and urge you to vote along with me. I thank the chairman.
The chair thanks gentlemen, and without objection, all other members' opening statements will be made a part of the record. I now recognize myself for purposes of offering an amendment in the nature of a substitute, and the clerk will report the amendment.
Amendment in the nature of a substitute to H.R. 5063, offered by Mr. Goodlatte of Virginia. Strike all that follows.
Without objection, the amendment in the nature of a substitute is considered as read, and I'll recognize myself to explain the amendment. On April 28, 2016, the Subcommittee on Regulatory Reform, Commercial and Antitrust Law held a productive hearing on H.R. 5063, the Stop Settlement Slush Funds Act of 2016. This substitute amendment refines and improves H.R. 5063 based on the expert feedback received at that hearing. The amendment rearranges some language, but ultimately makes just 3 principal changes. It adds a provision making clear that this bill applies prospectively only, thus it does not disrupt any existing settlements. Second, the amendment prevents DOJ from pressuring defendants to make donations even without actually requiring them. For example, the J.P. Morgan settlement offered credit for but did not require donations. The amendment accomplishes this by replacing the term requiring with directing or providing for. Third, the amendment substitutes the term payment for donation to prevent DOJ from circumventing the ban by recharacterizing the payment. DOJ has already begun to do that by requiring defendants in settlements to spend a sum of money working with a third party rather than using the term donate. The amendment is careful to exempt unobjectionable payments for administrative services rendered in connection with the case, for example, paying a settlement monitor. As in the underlying bill, payments to provide restitution for or to remedy actual harm are explicitly permitted. The amendment furthers the bill's underlying principle that spending policy decisions should be left to Congress by clarifying that such permitted payments must directly remedy the actual harm. In short, this amendment strengthens the bill, and I urge my colleagues to support it. And I now recognize the gentleman from Michigan, Mr. Conyers.
Thank you,
5 minutes.
Thank you, Mr. Chairman. Members of the committee, this Goodlatte amendment in the nature of a substitute clarifies that H.R. 5063 only applies to settlement agreements concluded on or after the enactment of the bill, and includes an exception for third-party payments for services rendered in connection with the case. This amendment in the nature of a substitute makes several positive changes to H.R. 5063, such as clarifying that the bill only applies prospectively to settlement agreements consummated after enactment of this bill. As introduced, 5063 would apply retroactively to the enforcement of existing settlement agreements, potentially preventing the enforcement of an untold number of settlements involving third-party payments. The manager's amendment also includes an exception for payments for services rendered in connection with the case, which appear to allow third-party payments for attorney fees and other fees associated with bringing a civil complaint. Notwithstanding these improvements to the bill, which I reluctantly admit, this amendment does not address the overarching concerns with H.R. 5063 that I expressed in my opening statement. Furthermore, this amendment does not resolve the material vagueness of the underlying bill. During the legislative hearings on 5063, both majority and minority witnesses expressed concerns that the bill did not adequately define key terms. Professor David Ullman observed that the bill does not make clear that it does not impose limitations on long-standing programs that address generalized harm, while noting that courts interpreting the legislation could conclude that it precludes third-party payments as part of civil settlement agreements other than restitution, even in cases of generalized harm to the environment or consumers. Additionally, Professor Paul Figley, a majority witness, expressed concerns that due to vague drafting, the bill may not achieve its goals. The legislative hearing on 5063 occurred less than 5 legislative days ago. The record is still open, which means that we have not had an opportunity to ask additional questions raised by both majority and minority witnesses during the hearing. Since that hearing, however, we have heard additional concerns from Professor Ullman that this amendment addresses, quote, addresses none of the problems with the bill, end quotation, and raises, quote again, raises a whole host of questions about what payments are covered, fails to define harm in a meaningful way, includes problematic causation language, and targets civil settlements for no principled reason, end quotation. With these concerns in mind, I must restate my opposition to this misguided legislation. And I yield back the balance of my time and thank the chairman.
Are there any amendments to the amendment?
Yes, sir. Yes.
What purpose does the gentleman from Michigan seek recognition?
Yes, sir. I have an amendment at the desk.
The clerk will report the amendment.
Amendment to the amendment in the nature of a substitute to H.R. 5063 offered by Mr. Conyers. Page 1, line...
Without objection, the amendment is considered as read, and the gentleman is recognized for 5 minutes on his amendment.
Thank you, Mr. Chairman. My amendment would exempt from the legislation settlement agreements that provide payments to third parties as general relief for violation of the Title VII of the Civil Rights Act of 1964. Title VII, you will recall, prohibits discrimination in employment on the basis of race, color, sex, religion, or national origin. Plaintiffs in employment discrimination cases typically seek payment and other relief for economic loss resulting from unlawful employer conduct. These cases often involve multiple victims subject to the same widespread discriminatory employment practice or policy that violated the Civil Rights Act in the first place. And they also tend to affect the interests of persons who are not parties to the civil action or who are otherwise unlikely to receive compensation for unlawful conduct. Given the often systemic nature of discriminatory conduct, settlement agreements should be able to provide for general relief for non-identifiable victims through such means as requiring payments to address generalized harm or to prevent future discriminatory acts. Examples include workplace monitoring and training programs. Nevertheless, H.R. 5063 would prohibit these types of payment remedies unless they provide restitution for actual harm directly and proximately caused by the party making the payment. At last month's hearing on the bill, the University of Michigan Law School professor David Ullman testified that this requirement would potentially preclude, quote, all third-party payments in settlement agreements other than restitution to identifiable victims, in quotation. The majority's own witness, our former colleague, Dan Lundgren, who previously served as California State Attorney General concurred. He observed that the bill prohibits the United States government from entering into a settlement agreement requiring a defendant to donate to an organization or individual not a party to the litigation, end quotation. I'm concerned that the bill's broad and ill-defined prohibition would effectively deter civil enforcement agencies from providing general relief in discrimination cases, discourage courts from enforcing these settlements, and invite costly and needless litigation concerning these provisions. And so accordingly, my amendment would accept payments to remediate generalized harms in settlement agreements in this important category of civil rights cases. And so I commend this amendment to each and every member of the Judiciary Committee and urge the adoption of my amendment. I thank the chairman and yield back.
Chair thanks the gentleman and recognizes himself in opposition to the amendment. I oppose the amendment because it reflects a fundamental misunderstanding of the underlying bill. This amendment would exempt certain discrimination settlements from the bill's ban on third-party payments, but nothing in the underlying bill prevents a victim of discrimination from obtaining relief. The Stop Settlement Slush Funds Act of 2016 explicitly permits remedial payments to third-party victims who were directly and proximately harmed by the defendant's wrongdoing. If there are no such victims, the defendant is not let off the hook. It still must pay, but in the absence of direct victims, the money goes to the Treasury for elected representatives to decide the best way to spend it. The point of this bill is not to effect restitution to victims, it is to address an institutional issue. The bill preserves Congress's spending power, which is its most effective tool for oversight and reining in executive overreach, no matter which party is in the White House. And accordingly, I urge my colleagues to oppose this amendment. First, the gentleman from Georgia seek recognition.
Move to strike the last word.
Gentleman is recognized for 5 minutes.
Thank you, Mr. Chairman. The Conyers Amendment I speak in favor of. It exempts settlement agreements in suits concerning discrimination on the basis of race, sex, religion, national origin, age, or disability. Civil rights laws embody some of our nation's most fundamental values, namely, no one should be treated adversely solely on account of their race, sex, religion, national origin, age, or disability. Settlement agreements in particular have been instrumental in enforcing various civil rights statutes in a wide variety of cases, ranging from those involving voting rights to reform of mental health institutions to law enforcement misconduct. Indeed, they are the heart of the civil rights enforcement. By making it substantially more difficult for agencies to enter into settlement agreements regarding civil rights enforcement, this bill effectively undermines Congress's statutory mandates to agencies concerning civil rights. Specifically, H.R. 5063 precludes payments for remediation of generalized harms and appears to restrict relief only to parties to a civil action. This provision substantially diminishes the ability of civil rights or civil enforcement agencies to provide general relief in discrimination cases and would deter agencies from pursuing such relief. I support this amendment. I urge my colleagues to do the same, and I would, though I have not read the lawsuit filed by the Justice Department against the state of North Carolina, its governor, McCrory, and the university system, as well as its law enforcement agencies, I believe that this legislation, without the Conyers Amendment, would preclude the effectiveness of that lawsuit, which is in the public eye as we speak. So with that, I'd ask my colleagues to support the Conyers Amendment, and I yield back.
The question occurs on the amendment offered by the gentleman from Michigan, Mr. Conyers. All those in favor respond by saying aye.
Aye.
Those opposed, no. No. Opinion of the chair, the noes have it. The amendment is not agreed to.
Mr. Chairman, may I have a recorded vote?
Recorded vote is requested, and the clerk will call the roll.
Mr. Goodlatte?
No.
Mr. Goodlatte votes no. Mr. Sensenbrenner? Mr. Smith? Mr. Shabbat? Mr. Isa? Mr. Forbes? Mr. King? Mr. Franks? Mr. Gomert? Mr. Jordan? Mr. Poe? Mr. Chaffetz? Mr. Marino? Mr. Gowdy? Mr. Labrador? Mr. Farenthold? Mr. Collins? Mr. DeSantis? Ms. Walters? Ms. Walters votes no. Mr. Buck? Mr. Ratcliffe? No. Mr. Ratcliffe votes no. Mr. Trott? Mr. Trott votes no. Mr. Bishop? Mr. Bishop votes no. Mr. Conyers?
Aye.
Mr. Conyers votes aye. Mr. Nadler? Ms. Lofgren? Ms. Jackson Lee? Ms. Jackson Lee votes aye. Mr. Cohen? Mr. Johnson? Mr. Johnson votes aye. Mr. Pierre-Louisi? Mr. Pierre-Louisi votes aye. Ms. Chu? Mr. Deutsch? Mr. Gutierrez? Ms. Bass? Ms. Bass votes aye. Mr. Richmond? Ms. Delbene? Ms. Delbene votes aye. Mr. Jeffries? Mr. Cicilline? Mr. Cicilline votes aye. Mr. Peters? Mr. Peters votes aye.
The gentleman from Wisconsin. The gentleman from Colorado.
Mr. Buck votes no.
Has every member voted who wishes to vote? The gentleman from New York.
Mr. Jeffries votes aye.
The clerk will report.
Mr. Chairman, 9 members voted aye, 15 members voted no.
And the amendment is not agreed to. For what purpose does the gentleman from Michigan, Mr. Bishop, seek recognition?
Move to strike last word.
Gentleman is recognized for 5 minutes.
Mr. Chairman, thank you for yielding and taking up this important issue. As we've heard today, in just the last 2 years, this committee has found the DOJ has directed nearly $1 billion That's a billion with a B to non-victim third parties through settlement agreements, and in the process completely circumventing Congress's spending and oversight authority. Of that 100 billion, over 500 million has already been dispersed or committed to being dispersed. In some cases, these mandatory donations provisions reinstate funding Congress specifically cut. Now, I want folks to understand $1 billion, Mr. Chairman. Do you know what the Department of Justice could do or could have done with $1 billion? And I reflect back to the city of Detroit this past weekend, where 7 were found dead, 14 were hurt in violence. New York City, Chicago, Baltimore, Los Angeles, other cities, the violence continues unabated. Rape kits continue to be unprocessed, leaving so many victims, thousands of victims behind. All of this require resources from the Department of Justice to enforce the law. Meanwhile, the Attorney General's office is focusing their attention on such things as my colleague from Georgia has just indicated, which is suing the states, and all the while ignoring the constitutional responsibility, their constitutional responsibility and ethical responsibility to enforce the law. I use, for example, in this case, the continuing existence of sanctuary cities, which represent, in my opinion and in many opinion of people that I represent, open and defiant violation of the rule of law. The Attorney General's failure to enforce the letter of the law is not only a serious violation of her oath of office and her duty as a prosecutor, as the chief law enforcement officer, but a blatant failure to ensure equal justice under the law. This is a real problem in this country. My constituents, and I know constituents and citizens around this country, have voiced an opinion of outrage as to how the Department of Justice, the Attorney General, the executive branch is using their resources. But to me, this is just symptomatic of a far bigger problem in the Department of Justice and the executive branch. And more than just being good stewards of money settlements, the DOJ is not following Article 1. This committee convened today to discuss a fundamentally bipartisan and institutional issue. Congress's spending power is its most effective tool for oversight and reining in the executive overreach. We must defend it. The tail has been wagging the dog for too long. Executive agencies cannot divert funds intended for taxpayers and the U.S. Treasury to fulfill their own personal agendas. This type of blatant disregard for our Constitution is not only an affront to our system of checks and balances, but threatens our democratic process. Mr. Chairman, I yield back.
For what purpose does the gentlewoman from Texas seek recognition?
Yeah. Okay.
Kind of got lost in
I have 2 amendments at the desk, Mr. Chairman, that I'd like to take en bloc.
The clerk will report the amendments, and without objection, they will be considered en bloc.
Amendment to the amendment in the nature of a substitute to H.R. 5063 offered by Ms. Jackson Lee. Page 1, line 9, insert after settlement agreement the following.
Without objection, both amendments will be considered as read and considered en bloc, and the gentlewoman is recognized for 5 minutes on her amendments.
I thank you very much, Mr. Chairman. Both of these amendments are amendments or issues that I've had firsthand experience with, either as a member of this committee or as an individual who has worked on issues dealing with sexual harassment and violence. And certainly my community was impacted deeply by the Deepwater Horizon settlement. In fact, I spent a lot of time in Louisiana, for example, and with oyster fishermen and wetlands preservationists and others who lived along the coast as far away as my home state of Texas. I know these issues, and I take issue with the concept of a slush fund. And as well, the majority knows that the Democrats and the Justice Department did not have time to review and negotiate changes to the bill prior to the markup. And this is a sweeping bill because it is, in essence, attempting to deny the reasoned assessment of the Justice Department on who we can help in the right way, how we can actually help and cure actual harm. I want to also make the point that the concern of violating the MRA, the Miscellaneous Receipts Act, is misguided because settlements agreements that require parties to distribute relief to third parties are not for the government within the meaning of the MRA and therefore fall outside of the appropriations powers of Congress. But my Amendment 1 deals with sexual harassment and violence settlement agreements. This bill only exempts payments to parties other than the government to provide restitution for actual harm directly and approximately caused by the party making the payment. At the subcommittee hearing on this bill, the minority witness, Professor David Ullman, testified that the bill would potentially preclude payments requiring monitoring and other payments for generalized harm. The proposed legislation currently drafted could be construed to preclude all third-party payments in settlement agreements other than restitution. Again, the majority witness specifically testified on behalf of the chamber that the bill should prohibit the U.S. government from entering into a settlement agreement requiring a defendant to donate to an organization or individual not a party to the litigation. That is wrong. Case examples. This amendment would accept cases where funds are directed to the remediation of generalized harm other than restitution to identified victims. Case examples will be impacted by my amendment. Female laundry workers receive $582,000. The consent decree resolving the case provides that in addition to paying $582,000, Suffolk Laundry will adopt new procedures to prevent sexual harassment, will train its managers, staff on identifying and preventing sexual harassment. The policies and staff training will be available in Spanish. EEOC will monitor Suffolk Laundry's compliance with these obligations. These women will now finally receive compensation for the abuse they suffered. We are confident that with the consent decree, they would not be victimized again. Centis Corporation, $1.5 million to settle EEOC sex discrimination case, would also be impacted negatively. And we are confident that the injunctive relief obtained provides a strong foundation for eliminating barriers to recruiting and hiring women. My second amendment, Deepwater Horizon settlement agreements directing payments to states as third parties, in fact, provides for relief that would provide states to remediate the generalized harm of unlawful conduct beyond harms to identifiable victims. Under the current law, the EPA may include supplemental environmental projects in settlement agreements to offset the harms of unlawful conduct by requiring parties to undertake an environmentally beneficial project or activity that is not required by law. This is crucial to wetlands and coastal areas. And so this broad-based legislation would be unfair and unfair to many victims. Let me offer into the record and read into the record the very eloquent, pointed, and constitutional statement of our Attorney General regarding discrimination in the case against North Carolina. In her statement, she says, "This is not the first time that we've seen discriminatory responses to historic moments of progress for our nation. We saw it in the Jim Crow laws that followed the Emancipation Proclamation. We saw it in the fierce and widespread resistance to Brown versus Board of Education. And we saw it in the proliferation of state bans on same-sex unions intended to stifle any hope that gay and lesbian Americans might one day be afforded the right to marry. That right, of course, is now recognized as a guarantee embedded in our Constitution in the wake of the historic triumph. We have seen bill after bill and state after state taking aim at the LGBT community. Some of these responses reflect a recognizably human fear of the unknown and a discomfort with the uncertainty of change. But this is not a time to act out of fear. My amendments clarify this legislation to not disallow the Justice Department from providing an actual cure to a harm by utilizing third parties to cure sexual discrimination and environmental major crises such as Deepwater Horizon, and to be able to allow payments to states as third parties for general remediation of harms, and then also, as it relates to the sexual harassment and violence, to exempt them to remediate the generalized harm of unlawful conduct beyond harms to identify victims. I ask my colleagues to support these two amendments en bloc to protect the innocent. I yield back.
Chair thanks the gentlewoman and recognizes himself in opposition to the amendments en bloc. These amendments would exempt settlements resolving workplace sexual harassment, violence, or discrimination, or providing restitution to a state. But nothing in the underlying bill prevents victims of workplace harassment, violence, or discrimination from obtaining relief or a state from obtaining restitution. The Stop Settlement Slush Funds Act of 2016 explicitly permits remedial payments to third-party victims who were directly and proximately harmed by the defendant's wrongdoing. If there are no such victims, state or individuals, the defendant is not let off the hook. The defendant still must pay. But in the absence of direct victims, the money goes to the Treasury for the elected representatives of the people to decide the best way to spend it. The point of this bill is not to effect restitution to victims. It is to address an institutional issue. The bill preserves Congress's spending power, which is its most effective tool for oversight and reining in executive overreach, no matter which party is in the White House. Accordingly, I urge my colleagues to oppose this amendment. The question occurs on the amendments offered on block by, for purpose, the gentleman from Georgia seek recognition.
I move to strike the last one.
Gentleman is recognized for 5 minutes.
Thank you, Mr. Chairman. I speak in support of the both Jackson Lee amendments submitted en banc. The first one exempts from the bill any settlement agreements that provide restitution to states, and the second exempts settlement agreements that pertain to payments to indirectly remediate and prevent sexual harassment, violence, or discrimination in the workplace. Attorney General Lynch stated yesterday that the lawsuit that the Justice Department filed against the state of North Carolina was about a great deal more than just bathrooms, she explained. This is about the dignity and respect we accord our fellow citizens and the laws that we as a people and as a country have enacted to protect them, she said. Indeed, to protect all of us. And it's about the founding ideals that have led this country haltingly but inexorably in the direction of fairness, inclusion, and equality for all Americans, end quote. Mr. Chairman, sex-based discrimination violates Title VII of the Civil Rights Act of 1964, which prohibits discrimination in employment on the basis of race, color, sex, religion, or national origin. This form of discrimination, which includes sexual harassment, is a persistent problem in the workplace. And according to the EEOC, more than 41% of the discrimination claims filed last year involved charges of sex-based discrimination, while more than 80% of the sexual harassment charges were filed by women. For example, EEOC settled a sexual harassment retaliation lawsuit in 2013 against Carroll's Corporation, the world's largest Burger King franchise, alleging widespread sexual harassment in the form of obscene propositions, exposure, or touching perpetrated by managers in the majority of the cases. According to the EEOC's complaint, many women, including teenagers, were fired or forced to quit because, quote, the harassment made their working conditions intolerable. Under the terms of that settlement agreement resolving the corporation of civil liability, Carroll's Corporation must pay direct restitution to victims and indirect restitution in the form of measure to increase the employees' awareness of anti-harassment policies, mechanisms for tracking harassment complaints, notice to inform employees of their rights, and other measures to prevent future unlawful conduct to third parties. H.R. 5063 will restrict the ability of the EEOC and other enforcement agencies from including similar terms in settlement agreements to provide general relief or prevent similar conduct. Also, the first part of the Jackson Lee Amendment exempts from the bill payments to states as restitution for generalized harm. As drafted, H.R. 5063 would only allow recovery to states that are parties to a complaint or otherwise directly harmed by unlawful conduct, and would prohibit payments for remediation of generalized or potential harms. Under current law, the Environmental Protection Agency, which includes supplemental environmental projects in settlement agreements to offset the harms of unlawful admissions or discharges by requiring parties to undertake an environmentally beneficial project or activity. And with that, I will yield to the gentle lady on her amendment.
Let me see if I have enough time left, but let me thank the gentleman very much. He made a very potent point. I thank him for his support. I want to just reemphasize, we're talking about for actual harm. So you're going to block through this legislation for the Justice Department to be able to utilize dollars dealing with sexual harassment and violence for actual harm to organizations dealing with monitoring and providing relief for actual harm. These organizations will work closely to prevent this kind of sexual harassment from happening again. And then, of course, my amendment dealing with Deepwater, we personally in the Gulf region were engaged with the Deepwater Horizon settlement. This was a painful experience. Besides the loss of life, this provides monies to states as third parties for general remediation of harms to Louisiana and other Gulf Coast states. It is an important statement to make. It may be another disaster that is in the Midwest or the West Coast, and this is disallowed. And so I ask my colleague, think of your own hometown. This legislation will block your own hometown from getting relief or your constituents from getting relief. I ask my colleagues to support my amendments. Mr. Chairman, may I ask unanimous consent to place into the record the statements of Attorney General Lynch on Monday, May 9th?
Without objection, it will be made a part of the record.
And may I also place into the record a letter from Public Citizen dated May 10th, 2016. And I thank my colleague, Mr. Johnson, for yielding.
Without objection, the letter from Public Citizen will be made a part of the record. The time of the gentleman has expired. Question is on the amendment. The amendments en bloc offered by the gentlewoman from Texas, Ms. Jackson Lee. All those in favor respond by saying aye. Aye. Those opposed, no. No. Opinion of the chair, the noes have it, or record vote is requested, and the clerk will call the roll.
Thank you.
Mr. Goodlatte?
No.
Mr. Goodlatte votes no. Mr. Sensenbrenner? Mr. Sensenbrenner votes no. Mr. Smith? Mr. Smith votes no. Mr. Shabbat? Mr. Issa? Mr. Forbes? Mr. King? Mr. Franks? Mr. Franks votes no. Mr. Gomert? Mr. Gomert votes no. Mr. Jordan? Mr. Jordan votes no. Mr. Poe? Mr. Chaffetz? Mr. Marino? Mr. Marino votes no. Mr. Gowdy? Mr. Labrador? Mr. Labrador votes no. Mr. Farenthold? Mr. Collins? Mr. Collins votes no. Mr. DeSantis? Ms. Walters? Mr. Buck? No. Mr. Buck votes no. Mr. Ratcliffe? No. Mr. Ratcliffe votes no. Mr. Trott? No. Mr. Trott votes no. Mr. Bishop? Mr. Conyers? Mr. Nadler? Ms. Lofgren? Ms. Jackson Lee? Ms. Jackson Lee votes aye. Mr. Cohen? Mr. Johnson? Aye. Mr. Johnson votes aye. Mr. Pierluisi? Aye. Mr. Pierluisi votes aye. Ms. Chu? Mr. Deutsch? Mr. Gutierrez? Ms. Bass? Ms. Bass votes aye. Mr. Richmond? Ms. Del Bene? Ms. Del Bene votes aye. Mr. Jeffries? Mr. Cicilline? Mr. Cicilline votes aye. Mr. Peters?
The gentleman from Virginia.
Mr. Forbes votes no.
The gentleman from Tennessee.
Mr. Cohen votes aye.
The gentleman from Michigan.
Mr. Bishop votes no.
The gentleman from Florida.
Mr. DeSantis votes no.
The gentlewoman from California.
Ms. Walters votes no.
Has every member voted who wishes to vote? The clerk will report.
Mr. Chairman, 7 members voted aye, 16 members voted no.
And the amendment is not agreed to. For what purpose does the gentleman from Georgia seek recognition?
I have an amendment at the desk.
The clerk will report the amendment.
Amendment to the amendment in the nature of a substitute to H.R. 5063 offered by Mr. Johnson. Page 1, line
Without
9.
objection, the amendment is considered as read, and the gentleman is recognized for 5 minutes on his amendment.
Thank you, Mr. Chairman. My amendment would exempt from the bill settlement agreements that resolve the civil liability of private parties under the antitrust laws. Excuse me. Under current law, the antitrust agencies may provide for both structural and conduct remedies in settlement agreements to resolve a party's anti-competitive conduct in violation of antitrust laws. Structural remedies in settlement agreements preserve competition through payments to third parties that are not actually harmed by anti-competitive conduct at the time of a transaction. These remedies typically include requiring a settling party to sell, divest, or license assets or rights to third parties to create new market competitors or strengthen existing competition. The Justice Department Antitrust Division noted in its 2011 policy guide to merger remedies that, quote, structural remedies in many cases can be simple, relatively easy to administer, and sure to preserve competition, end quote. The antitrust agencies may also seek to preserve and promote competition through conduct remedies that require payments to third parties to resolve a party's anti-competitive conduct or violation of the antitrust laws. These remedies may include prohibiting discrimination against other competitors who could be potentially or indirectly harmed by the settling party, requiring monitoring and auditing of a settling party to ensure compliance with a settlement agreement, or prohibiting retaliation against potential competitors. Importantly, both types of remedies are grounded in legal and economic principles to preserve and promote to preserve and promote competition through indirect remediation of unlawful conduct. As I noted during my opening statement, which will be submitted as part of the record, H.R. 5063 would cause waves of uncertainty and needless litigation by broadly prohibiting payments to third parties that were indirectly harmed by unlawful conduct. I'm concerned that if H.R. 5063 becomes law, it would prohibit the antitrust agencies from performing their statutory missions of promoting competition and preventing anti-competitive transactions. H.R. 5063 lacks any exception for structural remediation of anti-competitive conduct through divestitures or behavioral remediation of unlawful mergers through payments for compliance or transparency programs. In fact, the bill only excludes settlement payments that remediate actual harms that are directly and proximately caused by the unlawful conduct of a settling party. In the context of an anti-competitive transaction or other violation of the antitrust laws, this exception would only allow for payments to consumers if the antitrust agencies could prove after the fact that a monopolist raised prices. Likewise, an agency could only enter a settlement agreement directing payments to a third-party business that failed as a result of anti-competitive behavior, which is actually no remedy at all. Mr. Chairman, preservation of free markets through robust enforcement of the antitrust laws is a bipartisan concern. I urge my colleagues to support my amendment, which underscores the flawed premise of the underlying bill, and with that, I'll yield back.
Chair thanks the gentleman and recognizing himself in opposition to the amendment because it shows a fundamental lack of understanding of the underlying bill. This amendment would exempt antitrust settlements from the bill's ban on third-party payments. But nothing in the underlying bill prevents victims of an illegal trust from obtaining relief. The Stop Settlement Slush Funds Act of 2016 explicitly permits remedial payments to third-party victims who were directly and proximately harmed by the defendant's wrongdoing. If there are no such victims, the antitrust defendant is not let off the hook. It still must pay, but in the absence of direct victims, the money goes to the Treasury for the elected representatives of the people to decide the best way to spend it. The point of this bill is not to effect restitution to victims. It is to address an institutional issue. The bill preserves Congress's spending power, which is its most effective tool for oversight and reining in the executive overreach, no matter which party is in the White House, and I accordingly urge my colleagues to oppose the amendment. For purpose, the gentleman from Rhode Island seek recognition.
Mr. Chairman, moves to strike the last word.
The gentleman is recognized for 5 minutes.
Thank you. I rise in support of this amendment, which is really critical to ensuring that H.R. 5063 does not impair the ability of the antitrust agencies to enforce antitrust laws through settlement agreements. The Supreme Court has long held that the antitrust laws are core to promoting innovation, opportunity, and choice. In 1972, the court observed in United States versus Topco that the antitrust laws are, quote, the Magna Carta of free enterprise, because they are as important to the preservation of economic freedom and our free enterprise system as the Bill of Rights is to the protection of our fundamental personal freedoms. Congress has expressly granted authority to the antitrust agencies to prevent anti-competitive transactions through Section 7 of the Clayton Act, which prohibits mergers and acquisitions when the effect, quote, may be substantially to lessen competition or tend to create a monopoly, end quote. This authority includes the discretion to resolve civil complaints against parties for anti-competitive conduct that violates the antitrust laws. The bill before us, however, would prohibit any civil settlement agreement, including those resolving violations of the antitrust laws, that directs payments to parties that are not directly and proximately harmed by the unlawful conduct of the settling party. As others have eloquently argued this morning during this hearing, this measure in its current form fails to adequately address the fact that generalized harm arises in civil cases, including civil cases brought under antitrust laws. I'm concerned that the bill will undermine the efficient resolution of antitrust litigation and the deterrence of anti-competitive transactions and conduct through settlement agreements. This shortcoming of the bill in its present form may also result in even less consumer choice, less innovation, higher costs, and more power in the hands of fewer companies. Therefore, I really urge my colleagues to support this amendment, which ensures that H.R. 5063 does not undermine antitrust law enforcement efforts intended to promote competition, and urge my colleagues to support this amendment as well. And with that, I yield back.
I recognize myself for 5 minutes. The proceeds of any required sale do not go to third parties. They go to sellers. Conduct remedies do not include monetary payments. They are, by their nature, conduct only. The bill does not prohibit these. Now yield back. Does anyone else wish to speak on the amendment?
I move to strike the last word.
Chair recognizes the gentleman from Puerto Rico, Mr. Pillarisi.
I support the amendment, and I yield the balance of my time to the gentleman from Georgia.
Thank you, dear colleague. The chairman mentioned that my amendment evidences a misunderstanding of the bill, but actually what was suggested is that, or what the bill provides for, is that any monies that came from a settlement against a monopolist would then be, would go directly to the Treasury, so that Congress would then have the opportunity to allocate those funds to address the harm that the Justice Department filed suit against and won. So to think that this Congress, or any Congress for that matter, would be in a position to remediate harm that was found by anti-competitive behavior, I think is a misunderstanding of how this bill can be effective. In fact, it would render these kinds of judgments almost useless, because what would happen is that, let's take, for instance, this current Congress, which hasn't done a thing to address the looming Zika virus crisis that is approaching us this summer. It hasn't done a thing on the opioid issue as far as allocating new monies. The President has asked for supplemental funding to address the opioid abuse crisis in this country. Congress has done absolutely nothing, has done nothing on Flint water crisis in Michigan. It can't even pass a budget. And so to expect this Congress to remediate a harm from anti-competitive behavior by allocating resources that were generated from a Department of Justice lawsuit against a monopolist is almost ludicrous. And with that, I will yield back.
Does anyone else wish to be recognized? Seeing none, the question is on the amendment. Those in favor say aye. Aye. Those opposed, no. No. In the opinion of the chair, the noes have it.
Ask
Any
for a
members not
recorded
agreed to, or recorded voters, ask for. Call the roll, please.
Mr. Goodlatte? Mr. Sensenbrenner? Mr. Sensenbrenner votes no. Mr. Smith? Mr. Shabbat? Mr. Issa? Mr. Forbes? Mr. King? Mr. Franks? Mr. Franks votes no. Mr. Gomert? Mr. Gomert votes no. Mr. Jordan? Mr. Poe? Mr. Poe votes no. Mr. Chaffetz? Mr. Marino? Mr. Marino votes no. Mr. Gowdy? Mr. Labrador? Mr. Labrador votes no. Mr. Farenthold? Mr. Collins? Mr. Collins votes no. Mr. DeSantis? Mr. DeSantis votes no. Ms. Walters? Ms. Walters votes no. Mr. Buck? Mr. Buck votes no. Mr. Ratcliffe? Mr. Ratcliffe votes no. Mr. Trott? Mr. Trott votes no. Mr. Bishop? Mr. Bishop votes no. Mr. Conyers? Mr. Nadler? Ms. Lofgren? Ms. Jackson Lee? Mr. Cohen?
Soft
What do
back.
you say? Mr. Johnson?
I love him.
Mr. Johnson votes aye. Mr. Pierluisi? Mr. Pierluisi votes aye. Ms. Chu? Mr. Deutsch? Mr. Gutierrez? Ms. Bass? Ms. Bass votes aye. Mr. Richmond? Ms. Del Bene? Ms. Del Bene votes aye. Mr. Jeffries? Mr. Jeffries votes aye. Mr. Cicilline? Mr. Cicilline votes aye. Mr. Peters?
Any members who haven't voted who wish to vote? Gentleman from Virginia.
Mr.
The other gentleman from Virginia.
Mr. Goodlatte votes no.
That's it? Okay. Clerk will report.
Mr. Chairman, 7 members voted aye, 15 members voted no.
The noes have it, and the amendment is not agreed to. Are there any additional amendments?
Mr. Chairman.
Chair recognizes Mr. Cicilline.
Mr. Chairman, I have an amendment at the desk.
Clerk will report.
Amendment to the amendment in the nature of a substitute to H.R. 5063 offered by Mr. Cicilline. Page 1, line 9, insert after settlement agreement the following, other than the expected settlement agreement. Page 2, strike line 6, and insert the following.
Okay. The amendment is considered read without objection. Mr. Cicilline, you recognize.
Thank you, Mr. Chairman. My amendment would exempt settlement agreements intended to strengthen the personal privacy of American citizens from the blanket prohibition in this legislation. More specifically, it would preserve the ability of civil enforcement agencies to compel large corporations to adopt programs to protect consumer data. Under this bill, these agencies would be prohibited from reaching settlement agreements that provide payments to non-governmental parties. It would only exempt payments to provide restitution for actual harm, quote, directly and proximately caused by the party making the payment, end quote. As a result, H.R. 5063 in its current form would potentially prohibit payments for required monitoring and other payments for generalized harm. As Professor David Ullman of the University of Michigan Law School pointed out during the subcommittee hearing for this bill, it could, quote, preclude all third-party payments in settlement agreements other than restitution to identifiable victims, end quote. This is particularly problematic in the consumer privacy context, where the harms may be diffuse or systemic, and where preventing future infringements is often so important. In such instances, the most appropriate remedy may involve prescribing steps that effectively prevent future misconduct rather than one that focuses exclusively on addressing previous faults. For instance, the Federal Trade Commission has used its authority under Section 5A of the FTC Act to resolve complaints involving unfair or deceptive practices. As a part of settlement agreements for these complaints, the FTC typically requires the offending party to adopt a series of preventative privacy measures. These requirements usually include employee training and monitoring requirements, third-party auditing, regular testing of privacy controls and procedures, and other reasonable steps to maintain data security practices consistent with the underlying settlement. These steps are not frivolous, and the payments involved are not opaque contributions to any so-called slush funds. To the contrary, these programs are carefully tailored to protect consumer privacy. Such agreements are an important and substantive component of the toolbox that enforcement agencies have at their disposal. But under the terms of H.R. 5063 in its current form, these programs would likely be prohibited, since they do not provide restitution to an identifiable victim or a party to the litigation. My amendment would simply ensure that these agreements, which protect the privacy interests of American consumers, are not endangered by the bill's vague and broad prohibition on payments in settlement agreements. I urge my colleagues to support this amendment, and I yield back.
The chair recognizes himself in opposition to the amendment. This amendment would exempt settlement agreements pertaining to the protection of Americans' privacy, but nothing in the underlying bill prevents victims of a privacy invasion from obtaining relief. The Stop Settlement Slush Funds Act of 2016 explicitly permits remedial payments to third-party victims who are directly and proximately harmed by the defendant's wrongdoing. If there are no such victims, the defendant is not let off the hook. It still must pay, but in the absence of direct victims, the money goes to the Treasury for the elected representatives of the people to decide the best way to spend it. The point of this bill is not to affect restitution to victims. It is to address an institutional issue. The bill preserves Congress's spending power, which is its most effective tool for oversight and reining in executive overreach, no matter which party is in the White House, and accordingly I urge my colleagues to oppose this amendment. For purpose, the gentleman from Georgia seek recognition.
Move to strike the last word.
Gentleman is recognized for 5 minutes.
Thank you, Mr. Chairman. The Cicilline amendment I support. It exempts from the bill any settlement agreement concerning privacy protections with the increasing opportunities for governmental and private organizations to obtain, maintain, and disseminate sensitive private information of citizens, it's critical that we not prevent or delay enforcement of consumer protection laws designed to protect Americans' privacy rights. As Professor David Ullman noted during the hearing on H.R. 5063 that took place 2 weeks ago, this measure, quote, fails to adequately address the fact that generalized harm arises in civil cases, end quote, including cases brought under consumer protection laws such as Section 5 of the Federal Trade Commission Act. H.R. 5063 only exempts payments to parties other than the government to provide restitution for actual harm directly and proximately caused by the party making the payment. Congress has expressly granted authority to the Federal Trade Commission, however, to resolve complaints against corporations for unfair or deceptive acts or practices under Section 5 of the FTC Act. As part of resolving potential civil liability of corporations for unlawful conduct, FTC settlement agreements typically require parties to address generalized harms of unlawful conduct by adopting a privacy program, employee training and monitoring requirements, third-party auditing, regular testing of privacy controls and procedures, and other reasonable steps to maintain security practices consistent with the underlying settlement. The protection of Americans' privacy is not a Democratic or Republican issue. Indeed, it is one of the few that those across the political spectrum have long embraced. Yet, notwithstanding these shared concerns, this bill could impose burdensome requirements on settlement agreements that are intended to protect privacy. The amendment corrects this shortcoming in the bill by including an exception for settlement agreements that protect the privacy of Americans. And for that reason, I would ask my colleagues to support the bill or support this amendment. And with that, I will yield time to the gentleman from Rhode Island.
I thank the gentleman for yielding. I just want to reinforce, in response to the chairman's assertion that nothing in the legislation prevents an individual from receiving restitution. That's correct, but that is not what the amendment is intended to address. The amendment is intended to address those payments which may be part of a settlement agreement that are intended to protect the privacy interest more broadly. Things like employee training and monitoring requirements, third-party auditing, regular testing of privacy controls and procedures, and other reasonable steps to maintain data security practices consistent with the underlying settlement. They would, in fact, be prohibited under the legislation in its current form. So it can provide a remedy to an individual who's been harmed, but very often settlement agreements that involve issues of privacy and of consumer privacy in particular are intended to also prevent further or additional or future infringements of that privacy, and those mechanisms would be prohibited, or payments for those actions would be prohibited under this bill. So it's not that an individual whose privacy rights were violated wouldn't be able to get restitution. It's the effect of a broader settlement that would prevent that in the future, so that we could protect the privacy interests of Americans broadly would be prohibited, and the amendment is intended to remedy that portion.
Would the gentleman from Georgia yield? I appreciate the gentleman yielding. I just want to say in response to the gentleman from Rhode Island that the language in the amendment, in the nature of a substitute that is before the committee, the language is very clear that the types of payments that he's referring to are permitted. In subsection A, the last line says payment for services rendered in connection with the case, which would include the types of training programs and other monitoring services that the gentleman made reference to. This amendment is not necessary and goes beyond the scope of what the gentleman describes as the reason for the amendment, and therefore I must oppose it.
Will the chairman yield? I believe that, I'm sorry.
Yes, I yield.
That language refers to the costs associated with the litigation, not with the settlement. So I think, with due respect, Mr. Chairman, that constitutes payment for services rendered in connection with the case, refers to litigation costs, not costs that are part of a settlement agreement in terms of services or procedures that need to be put in place. With all due respect, I don't think that the draft, in fact, allows that.
I think the language is plain, and we'll have to disagree on that point. But I thank the gentleman.
With that, I yield back.
Question occurs on the amendment offered by the gentleman from Rhode Island. All those in favor respond by saying aye. Those opposed, no. No. Opinion of the chair, the
Chairman, I
noes
ask for a
have it.
recorded vote.
Recorded vote is correct, requested, and the clerk will call the roll. No.
Mr. Goodlatte votes no. Mr. Sensenbrenner? Mr. Sensenbrenner votes no. Mr. Smith? Mr. Shabbat? Mr. Isa? Mr. Forbes? Mr. Forbes votes no. Mr. King? Mr. Franks? Mr. Franks votes no. Mr. Gomert? Mr. Gomert votes no. Mr. Jordan? Mr. Poe? Mr. Chaffetz? Mr. Marino? Mr. Marino votes no. Mr. Gowdy? Mr. Labrador? Mr. Farenthold? Mr. Collins? Mr. Collins votes no. Mr. DeSantis? Mr. DeSantis votes no. Ms. Walters? Ms. Walters votes no. Mr. Buck? Mr. Buck votes no. Mr. Ratcliffe? Mr. Ratcliffe votes no. Mr. Trott? Mr. Trott votes no. Mr. Bishop? Mr. Bishop votes no. Mr. Conyers? Mr. Nadler? Ms. Lofgren? Ms. Jackson Lee? Mr. Cohen? Mr. Johnson? Mr. Johnson votes aye. Mr. Pierluisi? Mr. Pierluisi votes aye. Ms. Chu? Mr. Deutsch? Mr. Gutierrez? Ms. Bass? Mr. Richmond? Ms. Del Bene? Ms. Del Bene votes aye. Mr. Jeffries? Mr. Jeffries votes aye. Mr. Cicilline? Mr. Cicilline votes aye. Mr. Peters? Mr. Peters votes aye.
The gentleman from Texas, Mr. Poe.
Mr. Poe votes no.
Gentleman from Idaho.
Mr. Labrador votes no.
Has every member voted who wishes to vote? Clerk will report.
Mr. Chairman, 6 members voted aye, 15 members voted no.
And the amendment is not agreed to. Are there further amendments to the amendment in the nature of substitute? The question is on the amendment in the nature of a substitute to H.R. 5063. Those in favor respond by saying aye. Aye. Those opposed, no. In the opinion of the chair, the ayes have it, and the amendment is agreed to.
Mr. Chairman, I'll yield back.
A reporting quorum being present, the question is on the motion to report the bill H.R. 5063 as amended favorably to the House. Those in favor respond by saying aye. Aye. Opposed, no.
No.
The ayes have it, and the bill as amended is ordered reported favorably.
I'd ask for a recorded
A
vote.
recorded vote is requested, and the clerk will call the roll.
Mr. Goodlatte?
Aye.
Mr. Goodlatte votes aye. Mr. Sensenbrenner? Mr. Sensenbrenner votes aye. Mr. Smith? Mr. Shabbat? Mr. Isa? Mr. Forbes? Mr. Forbes votes aye. Mr. King? Mr. Franks? Mr. Franks votes aye. Mr. Gomert? Mr. Gomert votes aye. Mr. Jordan? Mr. Poe? Mr. Poe votes yes. Mr. Chaffetz? Mr. Marino? Mr. Marino votes yes. Mr. Gowdy? Mr. Labrador? Mr. Labrador votes yes. Mr. Farenthold? Mr. Collins? Mr. Collins votes aye. Mr. DeSantis? Mr. DeSantis votes aye. Ms. Walters? Ms. Walters votes aye. Mr. Buck? Mr. Buck votes aye. Mr. Ratcliffe? Yes. Mr. Ratcliffe votes yes. Mr. Trott? Yes. Mr. Trott votes yes. Mr. Bishop? Yes. Mr. Bishop votes yes. Mr. Conyers? Mr. Nadler? Ms. Lofgren? Ms. Jackson Lee? Mr. Cohen? Mr. Johnson? Mr. Johnson votes no. Mr. Pierluisi? Mr. Pierluisi votes no. Ms. Chu? No. Ms. Chu votes no. Mr. Deutsch? Mr. Gutierrez? Ms. Bass? Mr. Richmond? Ms. Del Bene? Ms. Del Bene votes no. Mr. Jeffries? Mr. Jeffries votes no. Mr. Cicilline? Mr. Cicilline votes no. Mr. Peters? Mr. Peters votes aye.
The gentleman from Utah.
Mr. Chaffetz votes aye.
Gentleman from California.
Mr. Issa votes aye.
Has every member voted who wishes to vote? Clerk will report.
Mr. Chairman, 18 members voted aye, 6 members voted no.
The ayes have it, and the bill as amended is ordered reported favorably to the House. Members will have 2 days to submit views, and without objection, the bill will be reported as a single amendment in the nature of a substitute incorporating all adopted amendments, and staff is authorized to make technical and conforming changes. This concludes our business for today. I thank all the members who have remained, and the markup is adjourned.